Welcome to Legal Bench 5, a channel where real courtroom cases are discussed in detail. Legal facts are carefully examined, and the process of justice is understood beyond the headlines.
Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir.
Okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had beer.
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beer.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
you.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because
What?
you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour
No. I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. He's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His and this scandal, I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Haywood.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second. I just want to make sure this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take
I appreciate Ms. Mackey because she provided me with the basic love. This is I think we're both at fault here.
It just felt,
She provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
because if it was up to me,
I fill these out myself. I
Correct.
appreciate it, Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she half did it.
Yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that, pardon?
1 year.
1 year, 2,000. It was a group effort. I like how they all
that
sat
again.
there and tried to protect each other. All right. May I have him sworn?
Solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. 2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for, explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Now, yeah, people.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case, People versus Derek Stevens.
Did I finish the name? Darius Johnson.
Brian Bowling on behalf of Mr. Johnson in case ending in 1734, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson and in the case ending in 5312. Mr. Johnson, state your full name for the record.
Darius Johnson.
Judge, we're asking that, my matter and speaking for Mr. Bird, his matter gets set for preliminary examination. I believe discovery to be complete in my case.
Correct, Your Honor. Both matters set for.
You understand we have a violation?
We do understand it's a violation. At first we thought it was a progress report, not technically a violation, Your Honor.
Because it said progress report at the top of a violation. It says violation.
Well, Your Honor, respectfully, it is a lot going on with my client. He had a medical marijuana card.
Does he have one?
He doesn't. He doesn't
I
have.
just gotta renew it. So you don't have one.
Expired. So I technically don't have one.
He doesn't have a medical marijuana. He doesn't have a medical marijuana card.
That's either you do or don't.
I don't.
You don't. Okay.
It expired in 2023. But my client does suffer from PTSD, Your Honor. He went to prison at a young age, at 18 years old. He did 5 years in prison. Self-medicating. Been self-medicating off of that right now. He is taking care of his little brother. His little brother's his dependent that depends on him. Has one child. He has built a successful life for himself with a successful clothing line, but still times is difficult, Your Honor. Taking care of his little brother, taking care of his 3-month son. Went out of town to see his son because he needed to.
Can I chime in? I just gotta know it's no excuse for me not having it. I just gotta you just give me an opportunity to get it. I can have it like tomorrow.
You can have what?
Tomorrow I can just go online and get it.
And he did come up here. And he knew it was going to be a chance.
Well, he was supposed to community corrections told him to discontinue use until he had that medical marijuana card was received and it was approved by the court. But you didn't do that.
Not in.
And that was back in January that they told you that. And you still continued to use.
I did.
All discovery is complete.
In my case, yes, Judge.
In my case, as far as I know, yes, Your Honor.
People have their witnesses available to 17. Preliminary examination in this matter will be set February 17, 2026, 9 a.m. before Judge Moore. At this point, you can't follow instructions and have you out. Bonds revoked. Defendant's demanded.
Gardner.
Your Honor, we are asking for an adjournment to review the discovery, and I'm hoping to make a bond argument as well.
Man, I lost my screen. Seeking an adjournment on this matter.
Please, Your Honor.
We'll adjourn the matter to the 19th. Probable cause conference will be adjourned February 19th. 2026, 9 a.m. Asked to bond.
Judge, Mr. Gardner submits that he can be safe community if given a PR bond. He reports to me that he was doing really well before he was arrested. He was working for a program that enabled him to work in exchange for housing, and it was going well. He believes that he can get back in if he's released. He's unable to get back in. He does have a place to stay with his sister, who lives locally in Washtenaw County. He will seek other work. He is motivated to resolve this, Your Honor, and he promises to attend all court dates and follow through with all bond conditions.
However, we believe that where bond is currently set is appropriate. This is a situation where, as I recall, we may have been staying at a hotel, and through the course of this, did threaten to kill or someone, right? To have them kill the officers who were involved and/or their families. We believe this gentleman is
He threatened to kill the officers in his family. Oh.
He is also just really dangerous to the public.
Anything else?
No, I leave it at.
I'm going to deny the motion for bond reduction. Bond will remain. Right. Thank you.
Yeah.
Case people versus Dara Akiji.
An Assistant Public Defender Jay Bellinger on behalf of Mr. Ikeji on all cases not ending in 1678.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji in case ending in 1670.
Your Honor, our client is present via Zoom from the jail.
Yes, sir. If you could state your name, please.
Greetings, honorable family, friends, and community members and township members. My name is Chidera Bennett DKG, and I'm entering into my rights to plead the federal Fifth Amendment, bonding me into the right to remain silent for the rest of trial. One of the only reasons the prosecuting party will proceed to provide lacking evidence is because they want me to forget the root cause of every case or pretension presented against me today. Last reason I'm providing you with is I'm prepared to stand in on the fact that I do not want my mother or my father provided with a stroke or heart attack, recognizing the county of Washtenaw, city of Ann Arbor, all within the
So are you going to be done soon?
I'm still speaking. Attempted to kill me.
Don't even try that.
As a victim.
Let's mute him because you can talk away all you want. What are we doing on this?
Your Honor, may we approach, please?
Well, sure. Go on. Okay, record should reflect we have bench conference in this case. The defendant has stood up but is still present in the room. We've received competency reports indicating that the defendant is competent Do we have any other additional evidence for the court to consider?
We don't, Your Honor. And as I stated at the bench, I understand that a new competency request was signed by this court, and then we got the report back right after. So we would be stipulating to competence on all of the files, despite the fact that there's still that outstanding competency order.
All right.
Your Honor, the people would stipulate have no further evidence as the court finds defendant.
Same, Your Honor.
If the defendant is competent to stand trial in this matter, I will sign the competency orders. I will then set a probable cause conference in this case. I will set a probable cause conference for March 5th.
Yep. Okay. Thank you very much.
2026, 9 a.m. Bond will continue.
Mr. Akechi, I will visit you. Thank you, Judge.
Thank you.
Next time.
All right. Thank you, sir.
Take care. Good to see you.
Wow. Let's copy that. The only difference around one is found at the top.